Hello and welcome to Mackenzie Friend. Today the question is, does mediation or initiating proceedings affect existing parenting orders? This question came up in a Facebook post where a parent stated that they did not have to abide by the orders whilst parties were in mediation, even though existing orders existed. But first, disclaimer, whilst I hold a law degree majoring in family law, I choose not to practice or seek admission. Therefore, any information cannot be relied upon. Specific questions should be directed towards an accredited family law specialist. Okay, basically the answer is no, and it's a big no. Orders can only be changed by consent, either by consent orders or provision under the orders or order of the court. Until then, they remain in effect. Orders must be abided by even when the child wishes not to see the other parent, a parent has an outstanding child support debt, the parent does not exercise the full extent of their rights under the orders, a parent is unwilling or unable to provide care for a child in strict adherence to the orders, perhaps due to business commitments, illness of a parent, financial duress, delay in tending handover on time, they might have car troubles, or might be traffic. So let's look at the case Gaunt and Gaunt, which has also been affirmed again in Wilson and Wilson. The genuine belief of the custodial parent that access would not be in the best interest of the child did not constitute just cause or excuse for not complying with the order. This specifically for the instance where we talked about a child not wishing to see the parent. The court made it clear that although the access order was open to variation under the Act in appropriate circumstances, while it stood the opinion of the custodian as the desirability of access did not constitute just cause or excuse for interfering with the operation of the order. Therefore, all those excuses before are not just cause or excuse for interfering with the operation of the order. Also, under the Australian Solicitors Rules, if a party is represented by a lawyer under 20.3.1, the Solicitors Rule, a solicitor whose client informs the solicitor that the client intends to disobey a court's order must advise the client against that course and warn the client of its dangers. Now, it's also important to note that protection orders can suspend, vary or discharge parenting orders. A state court can exercise jurisdiction under the Family Law Act to the extent it is possible consistent with the best interest of the child to make a family violence order. See Section 7, Children Division 11 of the Family Law Act. But this is an order of the court. If a court makes a Section 68R contact order, which is inconsistent with a family violence order, the judge or magistrate must explain to a number of people, including the person protected, the reasons for the inconsistency and the effect of the order. Section 68S of the Family Law Act spells out, which has always been the case as a matter of constitutional law, that Section 68R contact order, being an order made under Commonwealth legislation, prevails over inconsistent family violence order. Additionally, under 68T, that a court making a family violence order can, on its own initiative or on application by a person, make, vary or revive, suspend or discharge a Division 11 contact order. This also means that parenting orders can only be varied by the court. So, in conclusion, parents must abide by orders until the court determines otherwise. Any steps associated with seeking to change orders does not affect the duties and obligations under the existing orders. Parents who fail to abide by orders can be subject to a contravention application or litigation, which may result to changes to the orders or costs made against the offending party. I hope this helps.